Welcome to INAN's Advocate. INAN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Ashmita Goradia. We are glad that on the International Women's Day we have her here. Today she is going to speak on an overview of SEBI Act 1992 and its application and practice. Advocate Ashmita has graduated her law from Praveen Gandhi College in the year 2020. She has graduated her LLM recently from MNLU. Her areas of practice are commercial and civil laws. So without wasting further time, I'd request Advocate Ashmita to commence with her lecture. Thank you.
Thank you so much for the introduction. It is a pleasure and I'm extremely grateful for this opportunity to give a lecture, especially on Women's Day. Before I get into the topic, I would like to give you a brief background on SEBI Act. As you all must be aware of the Harshad Mehta scam. In brief, what Harshad Mehta would do was he would take fraudulent bank receipts from banks, use that bank receipts to take loans from other banks, and then use that money in the stock market to fraudulently manipulate the price of any one script that he chose. Either he would then sell those shares or he would further invest to again hike up the price. Now this all happened in 91-92 and SEBI was established. So SEBI was already there as a body in 1988. In 1992, after this scam, as a consequence, the government gave SEBI a statutory recognition. So SEBI Act was established, and under SEBI, under the Act, SEBI became a statutory body. Now the entire Act, right from section 1, it's been divided in a few chapters, right from section 1 to the last section. It gives powers, it defines what would be SEBI, what SEBI would be constituted as. Despite all of this, the administration of SEBI is entirely in its own hands. That is, it is an autonomous body. Now, SEBI has been established for 3 purposes. If you read the long title, I would also recommend that all of you, if you have your act or any computer near you, just open the SEBI Act and perhaps with me go through the relevant provisions that I will now tell you. So, if you read the long title or the preamble of the Act, you will find that it is established for 3 purposes. It is established, 1, for the protection of interest of investors, 2, for regulation of securities market, and 3, for promoting development of securities market. Now throughout the Act, you will find powers given to SEBI to, 1, in the performance of its duty and for the protection of investors, for regulating the market. Powers have been given to SEBI to draft regulations, to execute those regulations, and to adjudicate those regulations. It is perhaps one of the only bodies which has been given all 3 powers: legislature, executive, and judiciary. So under the management of the Act provides there has to be 1 chairman, 2 members nominated by the central government who are in the field of finance, 1 member of RBI nominated by RBI, and 5 other members, of which at least 3 members will have to be whole-time members appointed by the central government. Now in practice, one of the main provisions where SEBI derives its powers is section 11. Section 11 and section 11B, all of those continuing sections, it's in chapter 4. So section 11(1), subsection 1 gives the duty to SEBI for meeting its objectives. It gives a duty and gives powers to SEBI to take measures as it deems fit. Second, in subsection 2, it gives a list of measures that it can take. For instance, there's provision for making regulations for prevention of insider trading, prohibition of fraudulent and manipulative practice. Then you also have registration of stock exchanges, which forms part of the powers of SEBI. All of those things are there in section 11. Section 11 further says that it also has the powers equivalent to a civil court, where a civil court is trying a suit. So summons and all the powers, so calling for papers, everything which a civil court can do in the process of the trial, the SEBI has those powers. And 11.4 is one power where in the interim pending any investigation, it, in the interest of investors, it can take any measure it deems fit. For instance, it can issue directions of debarment, it can issue say you cannot be a part of any company as a director. All of those provisions, even before investigation has completed, it can issue directions like those. So what has always happened is SEBI has always been given these powers. Now every time a new scam comes in, SEBI realizes, or the government realizes, that there has been some lacuna in the provisions of the act itself. So what it does is, for instance, when the Sahara scam came in, this was around 2002, if I am not mistaken. But as a consequence of the Sahara scam, it introduced section 11AA, which is basically a prohibition on collective investment scheme if it is not registered with SEBI. So major amendments to SEBI Act has been as a consequence of the scams which have happened before, and as a result, provisions, powers have been increased of SEBI. Now in practice, what happens is, where say SEBI has some grounds to believe that you are in violation of some provision, it will first investigate in the matter. Second, it will then issue you a show cause notice. Third, it will then give you an opportunity for a hearing. Once it has heard, then the relevant authority will pass an order. Now what I intend to do is, I will take you through one order. I have pulled out the order in the case of Vimal Oil and Foods Limited. You will find this order in the SEBI, on the SEBI website itself, under the caption of enforcement. So the order is dated 24th March 2023. Now if you are with me, you will see the first part of the order. It says, under section 11.1, 11.4, 11.4a, 11b1 and 11b2, read with section 15g of Securities and Exchange Board of India Act 1992, read with Securities and Exchange Board of India Procedure of Holding Inquiry and Imposing Penalties Rules 1995. So generally, when a show cause notice or when an order is issued, it derives its power from SEBI Act. So these are the relevant sections through which it has the power to issue you a show cause notice and pass an order. While SEBI Act gives a broad outline of powers, because it also has power to draft regulations, so your major substantive charges would be under, in this case, it is prevention of insider trading regulations. So in this case, the charges are under section 3.1 and 4.1 of PIT regulations. The allegation in this case was that the notices were insiders and that they traded on the basis of inside information that they had and gained profits. So what we will do is, while I am not going to get into the merits of the case, what I will do is, I will show you exactly what provisions are applicable which SEBI has applied to bring in this allegation and thereafter decided on the case. And also along with it, the process which is followed by SEBI. Para 1 first, SEBI has conducted an investigation in the scrip of Vimal Oil and Foods Limited to ascertain whether certain persons, entities had traded in the said scrip on the basis of the unpublished price-sensitive information during the period July 1, 2015 to August 27, 2015. In contraventions of the provisions of SEBI Act, read with SEBI Prohibition of Insider Trading Regulations 2015. Now, there are two things that you will see. One, they have conducted an investigation. This investigation is a power derived under 11C of the SEBI Act. And second, on the basis of this investigation, they have issued you a show cause notice. So, whenever any person receives a show cause notice, while you will not find this anywhere, SEBI is bound by principles of natural justice. The first thing that you should do is immediately call for inspection, because while they will give you certain papers, they generally do not give you an investigation report along with it. So call for inspection, get an investigation report, see what are the allegations, what is the what basis is it that they have framed you with these charges. So in the show cause notice itself, now they will say, pursuant to the investigation, these are the observations that they have found. Now see para 3. It's the charges that they are referring to. In view of the trading in the scrip of VOFL by the notices when in possession of UPSI being connected persons in terms of Regulation 2, subsection 1, subsection D, Roman 1, and hence insiders, the notices were alleged to be in violation of. Notice numbers 1 and 2 were alleged to have violated the provisions of Regulation 4, subsection 1 of PIT regulations read with section 12A, subsection D and E of the SEBI Act. Subsection 12A, D and E of the SEBI Act gives powers to SEBI where it's to take measures it deems fit where there is an allegation of insider trading. The substantive portion of what constitutes insider trading, etc., will be there in the regulation, but SEBI Act under this section broadly gives powers to SEBI to investigate wherever there is a case of insider trading. Now when you come to para 4, you will see that there is an entire process of show cause notice, replies and hearing being followed. So there was a show cause notice issued by SEBI to these notices. Relevant provisions of SEBI Act were given. And in this case, so earlier what used to happen was, you had two separate notices which they would give. One would be sent by a whole-time member, where the provision would be, where the purpose of it would be, say, a debarment. So debarment powers were only with whole-time members and not with adjudicating officers. Now, there was a certain change in the delegation of powers, etc. in 2022. So now an adjudicating of a chief general manager, the designations have also changed, while the powers and while the terminologies also remain, but in terms of the new designations which have been given, a chief general manager or an executive director can do both, can also penalize you, can also pass interim measures or any directions against you. So therefore, when you read this, you will find that they are saying that under these sections, you tell us why we should not issue directions against you, or for example, restrain or debarring your access from the market, and 2, why we should not penalize you. So in this case, what the notices first did was they filed a settlement application. Now there's also a provision of settlement in the Act itself, that where the noticee is not inclined to take it up with the authorities, and this is in no way admission. Even the specific settlement regulations say so, that this is in no way an admission of any charges. It is without prejudice that you are settling with SEBI, and you also have an option of keeping it confidential. So in this case, these notices attempted to settle. However, for some reasons, they could not come up with a second settlement, a revised settlement option, and therefore they continued with the hearing. Para 49. Now here, when the officer refers to what was violated, they will always refer to your regulations. So they say, I find it important to refer to regulations 3 sub-regulation 1 and regulation 4 sub-regulation 1 of the PIT regulations. On a plain reading of regulation so and so, then it goes on to say, dissect the ingredients of the regulations. It does not in here refer to SEBI Act. However, when you finally come to the findings, which you will find in para 57, please come to page 36. You will read, I am constrained to conclude that noticee numbers 1 and 2 cannot be said to be in violation of regulation 4 sub-regulation 1 of the PIT regulations read with section 12A, D and E of the SEBI Act 1992. These are so how you have IPC and then you have special acts, Similarly, your power is derived from 12A, D and E for insider trading, and then you have the regulations which will be the charging regulations. In this case, the officer held that I do not find the instant case fit for issuing any directions under section 11.1, 11.4, 4A, 11B1, 11B2 of the SEBI Act, and or imposing any monetary penalty under section 15H2 of the SEBI Act 1992. Now for this, let's go back to SEBI Act. You have your powers given under sections 11, 11.4, all of these sections which are referred to here. Then you have section 12DE, which is your charging substance regulations. And then you have penalizing regulations, where power has been given to SEBI under sections 15, from sections 15A to 15JB. All of these are penalizing sections. In that, so for each violation, for insider trading, there would be 15G. For fraudulent, there would be another relevant section of section 15, whichever section it is. So, and the power to adjudicate is also derived from section 15I of the SEBI Act. So, while these are the primary powers, there is for criminal prosecution now there are separate sections. So all of this comes under SEBI, where under SEBI's own regulation, it will impose penalties. So they have only the power to impose penalties or a power to take interim measures or finally measures of debarment or any other power which it deems fit. However, for criminally prosecuting a matter, SEBI is not the adjudicating authority. Under section 24, section 24 and 11C6, it has acknowledged that powers for criminally prosecute, so 24.1 and 24.2 are substantive provisions for criminal prosecution, and throughout the Act you will see that a criminal court, a specially constituted bench of SEBI, has been given powers to adjudicate cases where SEBI would then be a complainant and against the accused, where the notices are then becoming an accused, where SEBI thinks that it is imperative that criminal action also be taken against them. So in a criminal prosecution, it is very important when you are in practice that you have all the material that they have used to frame charges against you. For instance, while I will not name the cases that I am handling right now, in one of the cases that I came across, I found that in the investigation report itself, there is so first SEBI has to take authority. So while SEBI adjudicates in a criminal matter in its name, there are certain internal processes which it has to follow. For example, if SEBI wants to initiate a prosecution, it has to take an approval from a whole-time member. So in the case that I had a chance to deal with and read about, the prosecution, the WTM approval was absent. While I will not share what happened in the matter, but a sanction of a WTM member is essential. Now, where will you find, if you do not have the internal process documents, where will you find that the sanction itself was not there? So in that's where your investigation report comes in, where they have a section of recommendations where they will say that these are the recommendations which we are making against these accused, where they will identify whether adjudication proceedings, whether WTM proceedings, or whether criminal proceedings are to be initiated, or whether all three are to be initiated. So in this specific case, this was absent, and therefore even though SEBI was prosecuting, the entire prosecution would be termed as invalid because its own board has not given it the recommendation and the approval of a whole-time member is missing. So all of these things, so every provision has been provided for under the SEBI Act itself. Oh yes, one aspect which I missed out is, while these are the executive, investigation is an executive power, carrying out inspection, all of these are executive powers, and while I've also dealt with judicial powers, there's also legislative powers which SEBI has, which is covered under section 2930 of the SEBI Act. 29 provides for SEBI to make its own rules, and 30 gives provisions for regulation. So if you ever read any of the regulations, in the preamble, it would say that the powers are derived from section, regulations of section 30 of the Act. Along with them, they would say that it is for the purpose of this. The purpose is also covered under section 11 of the SEBI Act. Now, all of these rules, regulations under section 31 mandatorily have to be put up before the Parliament for a period of 30 days. Whether or not this is followed is another question, but as per the Act, they are supposed to place it before the Parliament, and if Parliament does not find fault with it, then the provision continues as it is. If the Parliament feels that it has to be modified, then it gives for modification, and thereafter, at least until the modification, whatever Act that SEBI, whatever acts which were taken under those regulations, those remain valid. That the subsequent modification does not make any of the previous acts invalid. So this was the legislative part of it. Now I have covered everything. So just remember, whenever you get a show cause notice, first step is to always ask for inspection, and thereafter see what regulations, under what provisions they are charging you with, and always take legal advice is what I would suggest. But if you're doing it on your own, then first step is always know what is the case against you. Thank you.
Ashmita, thank you very much.
Thank you.
It was a nice overview of a very technical and a very, I would say, a very act which is much into issues. So you have nicely explained that, and you have taken the help of a particular case law for explaining the law. So thank you very much, and a small token from Hammurabi to you.
Thank you so much.